And let me give you some proper names that come out.
Okay.
On your 140 jury charge number 1, you have Miss Kidd, K-I-D-D, and Miss Pitney, P-I-T-N-E-Y.
Is that Miss M-I-S-S?
Period. No, M-S period.
M-S. Okay. On both?
Yes, on both.
Okay.
Okay. And that's it. So
okay.
That's it. So this is going to be your jury charge. I'm going to go ahead and mute you. Okay, Monica?
Yes.
Number 1, final exam for 5 minutes, and it starts in the middle. Just as I did at the start of this case, ladies and gentlemen, I am going to give you a summary of each party's contentions in the case. I will then give you the detailed instructions on what each side must prove in order to win on each of its contentions in this infringement case. As I previously told you, ladies and gentlemen, the patent holder in this case is Miss Pitney, and she is seeking money damages from Miss Kidd for allegedly infringing her patent by making, selling, and offering for sale products which Miss Pitney argues are covered by the claims of the patent. Miss Kidd denies that she has infringed the claims of the patent and argues that, in addition, the claims are invalid. Your job, ladies and gentlemen, is to decide whether Miss Kidd has infringed the asserted claims of the patent and whether any of the claims of the patent are invalid. If you should decide that any of the claims of the patent have been infringed upon and are not invalid, you will then need to decide any money damages to be awarded to Miss Pitney to compensate her for the infringement. You will also need to make a finding as to the question of whether or not the alleged infringement was willful. If you decide that the infringement was willful, ladies and gentlemen, your decision should not then affect any money damages you award to Miss Pitney. Before you can begin to decide the issues in this case, ladies and gentlemen, you will need to understand the role of patent claims. Patent claims are the numbered sentences that you see at the end of each patent. The claims are important because it is the words of the claims that define just what it is that a patent covers. The text in the rest of the patent are a written description of the product, and they give us a context for the claims, but it is the claims that do the work of defining all of the patent's coverage. Each and every claim is treated as if it were a separate patent, and each may claim more cover or less than another claim. What a patent then covers depends in turn on what each of its claims covers. Ladies and gentlemen, I know this isn't easy material to digest, and we have a lot to cover. I appreciate the attention which you are giving to the matter. We can take a recess for a few minutes if you like to give your minds a rest. All right, let's break for 10 minutes. We are back on the record now, ladies and gentlemen. We left off with the instructions of patent claims. You will next need to understand what each claim covers in order to decide whether or not there is infringement of the claim and to also decide whether or not the claim is invalid. The law states that it is my role to define the terms of the claims, and it is your role to apply my definitions to the issues that you are asked to decide in this case. As I explained to you at the start of the case, I will give my definitions of some of the claim terms we will cover in this case. As the jury, It is your role to accept my definitions of these terms in the claims as being correct. It is your job to take the definitions as I give them to you and then apply them to the issues that you are to decide in this case. I will first explain how a claim is created to define what it covers. What a claim does, ladies and gentlemen, is to set forth in words a set of requirements. Each claim sets out a requirement in one single sentence. For a product to be covered by a claim, it has to satisfy the written requirement of the claim. Another aspect of all of this to keep in mind is that there can be several claims in a patent. When a thing such as a product meets all of the requirements of a claim, okay, and then we have your 140 number 2, and it says no proper names. Let me make sure. Any questions, Monica?
No, no questions.
Okay. Okay, I don't see any, okay? This is going to be 140 number 2, test, final exam, jury charge for 5 minutes. Ladies and gentlemen of the jury, one of the people who gave evidence this afternoon was an expert witness. It was the lawyer of the plaintiff who asked him to assume certain facts and then asked him further to give his expert opinion based on those assumed facts. In the law, we call this a hypothetical question. You can consider this expert opinion only if you believe that the assumed facts are correct. If you decide that the facts given to the expert in the hypothetical question have not been proved here, then you can't really give any weight or credibility to the opinion. There is the second defense in play here that the defendant was easily influenced. Well, the truth is there are a lot of people who are easily influenced, and there are an equal amount of people who are not easily influenced, but the truth is they are all capable of doing business unless they are so incompetent that they really don't understand the nature of the business dealings or the transactions they are involved in. The public and those who deal with them are not required to be their guardians as long as they are dealing in what we call good faith. If the defendant paid this money in good faith, he is entitled to recover it unless, as I have stated, he was incompetent to the degree that he truly did not understand the nature of the business deal and he didn't know or understand what he was doing. If, though, he had reasonable knowledge about what taking out a loan or borrowing money meant, he was able to handle his business until he was declared incompetent by the courts. Was he in such a mental condition at the time that he agreed to loan money so as not to be capable of understanding what he was doing? It does not make any difference if he was afterward declared to be incompetent by the courts. The fact that a person is declared incompetent today by a court doesn't show that he or she was incompetent at any time before that, and including when they agreed to loan money. As a jury, it is for you to say here now, on the evidence presented to you, whether or not the defendant loaned out his money in such a mental condition that he truly did not understand what he was doing at the time. In this case, ladies and gentlemen, the defendant alleges that the loan in question was obtained from him while he was in a certain mental state due to his depression, and that at that time he was not aware of what he was agreeing to do. the defendant states that he felt he had to sign for the loan because he was familiar with the plaintiff and trusted her to pay him back in a timely manner, but that he also didn't realize the full extent of what he was being asked to do. The note for a loan that the defendant wrote to the plaintiff is being sued for in this action. It is a written promise to pay money, and it is not a negotiable note and does not carry with it the same presumption as a negotiable note would. A written promise to pay money is valid under the law unless a valid reason to not repay has been proven. Ladies and gentlemen of the jury, if you find there are conflicts in the statements of any of the witnesses, you will want to try to reconcile them if you can without deciding that any witness has not been truthful on the stand, because the law presumes that all witnesses are attempting to tell the truth. In forming your opinion as to the weight and credibility to be given to the testimony of the witnesses, you will look to the general character of the witness, and in that way, you will determine what weight you think should be given to their testimony. In an action such as this, wherein the defendant offered evidence of being a law-abiding citizen who is considered in his community to be honest and truthful, and then we have your 120s. You're going to listen to these, right, Monica?
Yeah, I'll stay on.
Okay. And so we have 120 number 1. Proper names on your 120 jury charge final number 1. None. Okay, no proper names. This is going to be 120 jury charge number 1 for 5 minutes, final exam. Ladies and gentlemen, we have reached the end of the trial, and you will now go to the jury room to deliberate a verdict. I suggest that before you get started, you elect one person of the 12 to be your presiding juror. Once you have done that, you are free to proceed as you feel is appropriate. I am not telling you how to go about your business, but I am offering you some ideas that other juries have seen as helpful over the years so that you are able to make the most of your time in the jury room and arrive at a verdict that is satisfactory to each and every one of you. It will be the responsibility of the presiding juror to see that communication among the 12 of you remains open and fair, and that all of the jurors have an equal chance to talk and express their opinions. It is the responsibility of the presiding juror to let each of you speak and be heard. It is the responsibility of the presiding juror to not promote his or her own views and opinions through bullying of others, and to ensure that no one else tries to promote their opinions through bullying. Bullying, by the way, includes coercion and intimidation. None of those things are permitted in the jury room, and all are a hindrance to reaching a verdict. It is the responsibility of the presiding juror to see that the deliberation process is not rushed in order to reach a verdict. This is not a process that should be done in haste. If the presiding juror you choose doesn't meet the above-mentioned standards, then he or she should step down or be replaced by a vote of the remaining 11 jurors. I have had some juries who are tempted to hold a preliminary vote on a case they are deliberating in order to see where they stand, so to speak. It really isn't a good idea to do that. I feel that it is jumping the gun. It is advisable that no vote be taken before a full and complete discussion is had on the issues to be voted on. It is far too easy to get locked into a particular stance before considering other and possibly more accurate and reasonable meanings of the evidence. Experience has shown me that taking an early vote, as I have just described, often leads to nothing more than ineffective debate. Your time can be better spent on deliberating without an early vote. I would like to suggest that the presiding juror start off your deliberations by setting some sort of basic ground rules for how the jury will proceed. Those ground rules will assure that you will keep your focus on the evidence and that each and every one of the jurors has an equal chance to be heard and your opinions considered before any actual decisions are made. You can agree to discuss the case in the order of the questions presented in the special verdict form if you see fit, or you can agree to discuss the case in the order of the testimony of each of the witnesses. The point being that whatever order you choose to start with, it is a good idea to stick to that plan and be consistent rather than jumping from one subject to another. As it is common for a jury to stall out on some of the more divisive topics that will arise in the jury room, it is wise to pass on those and then we have your 120 jury charge number 2, proper names. You have Mr. Arnell, Garrick, Corning, and Sheridan County. Any questions, Monica, on anything there?
No, no questions.
120 number 2 for 5 minutes, jury charge, final exam. Members of the jury, the charge in the indictment I have before me is that of murder. The murder is alleged to have been committed on December 7th of last year. It is alleged to have been committed in Sheridan County in the city of Corning. The defendant in this case, Arnell Garrick, has pleaded not guilty to the charges. Mr. Garrick is charged with murder because he is alleged to have caused the death of another. The term homicide means the killing of a person by another person. The term premeditation means that a plan is formed to do something at a time before it is done. Be advised that a person who acts with knowledge with respect to the nature of his conduct or to the events surrounding his conduct is a person who knows the nature of his conduct or knows that the circumstance exists. A person acts knowingly with respect to a result of his conduct when he is aware that his conduct is reasonably sure to cause the end result. A person is responsible if the result wouldn't have occurred except for his conduct. The defendant in this case is on trial only on the charge contained in the indictment. The state has produced other instances than the ones that are charged in the indictment. And in regard to those, I warn you that this was done only to rebut the defense of a mistaken identity. As you know, this case is based on the testimony of an eyewitness to the murder, and you must give that witness's testimony the most careful consideration. Before the defendant may be found guilty, however, there has to be other evidence, either direct or circumstantial, that supports the accuracy of the identification of the defendant by the eyewitness as the perpetrator of the crime with which he is charged. There are two kinds of evidence that a jury can use in finding the truth as to the facts of a case. One is direct evidence, such as the testimony of an eyewitness, and the other is indirect or circumstantial evidence, which is proof of facts which are supported by other facts. The identification of the defendant by an eyewitness to the crime must be taken into consideration with all the facts and circumstances that existed at the time the eyewitness observed the crime. In a criminal trial such as this one, every element of a crime has to be proven so unmistakably that before the jury can convict the defendant of the crime, you must be convinced of its truth beyond a reasonable doubt. In a trial of a charge of murder, a killing is lawful if it is excusable. The burden is on the prosecution to prove beyond a reasonable doubt that the homicide was unlawful and not excusable. If you have a reasonable doubt in your minds that the homicide was unlawful, then you must find the defendant not guilty. Remember that the defendant is not on trial here for any act or conduct not alleged in the indictment. Our laws provide that a defendant may testify in his own behalf if he chooses to do so. This is a privilege given to the defendant, and in the event he chooses not to take the stand and testify, that can't be used as a circumstance against him. A defendant who is charged with a crime is to be presumed innocent until proven guilty. The defendant in this case, Mr. Arnell Garrick, denies that he is the person who committed the murder of which he is accused and is okay. And so, Monica, what I'm doing is I'm breaking them up into two separate files, okay?
Okay.
So I'm going to log off and then I'll log right back in.
Okay.
Okay? Thanks.
Okay. Okay.
Uh-huh.